It's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning. Welcome to December and welcome to The Law Show here on AM 650. I'm joined in studio by David Hobbs and Ian Giroday from Hobbs Giroday, LLP in Vancouver. Welcome back, guys. Good to see you again.
Good to see you, Sterling.
Compliments of the season, Ian.
Thank you, Sterling.
It's December. We can do that now.
I can turn on my Christmas lights.
You know, the Christmas crazies have had their lights up for weeks already. This is just the validation of all of that energy that's been going on for so many weeks. Good to have you with us. I want to talk a little bit about Hobbs Giroday before we get into the whole mattership of, well, avoiding challenges to wills that frequently occur down the road. But tell us about the firm. Ian, why don't we start with you? Tell us about Hobbs Giroday and where you are and what you do and how long you've been in business. Those important details, please.
Sure. David and I have had a partnership since 2005. We have an office on Howe Street in downtown Vancouver, right across from the courthouse. And we are a litigation firm, and we spend a lot of time dealing with estate disputes.
Okay, so Vancouver estate litigation lawyers, David Hobbs. Take it from there and tell me what that means. What exactly do you do?
Well, we advise people who have disputes regarding estates, which is the distribution of somebody's property to some group of people, maybe family, maybe others. And we also help people with the process of probate, which is someone has passed away and there needs to be an executor appointed under a will, or there may need to be an administrator. So that whole process of appointment and getting to paying creditors and distributing the estate.
Ian, what, and I know you don't like ballpark figure questions, but give me one anyway, please. In terms of wills that are organized and people die, what percentage of wills, on average, are challenged? Is there some way there's some member, some person perhaps unnamed or named to a lesser degree than they're happy with? What percentage of wills actually end up in dispute?
I'm not aware of any statistics that would give me an answer to that.
Okay.
And you have to appreciate that there's different ways that a will might be attacked.
Okay.
There can be issues as to whether it's valid in the first place for a variety of reasons, or it could be valid, but a spouse or child might challenge it on a will's variation claim.
Okay.
If I had to hazard a guess, I would think that it would be less than 10% of all wills.
Interesting. And yet, of course, that's still an awful lot of work on an annual basis, isn't it, David?
Oh, definitely. I mean, unfortunately, we're all going to meet the maker at some point. People are passing away, and there's these constant flow of estates that have to be dealt with.
When we talk about, and this phrase, friends, is going to come up a lot in the following hour, we're going to hear about something called a will's variation. And that is just a legal term, Ian, for a change to the will. Someone applies for a will's variation. Someone wants something in the will changed, correct?
That's correct, Sterling. It's not an attack on the whether the will is valid or not.
Okay.
That a will's variation accepts that the will that is being sought to be varied is valid. It's either a spouse or child, because they're the only people under British Columbia law who can seek to vary a will. It's one of them or one or more of them coming forward and seeking the court's assistance in getting the will varied in their favor. And it's based on the idea that they were either disinherited entirely, or that they feel they were treated unfairly under the will.
And David, so typically a person who would come to you and Ian at Hobbs Giroday would be what? Someone who has been, who feels shortchanged in some way as a result of being included or not in a will. Is that correct?
Correct. I mean, Ian's made the point that they're they're either the legal spouse or common law spouse, i.e. legally, married, church-like marriage, or a common law spouse, or a child, biological child, or adopted child. And so it's that type of person. Generally, if you're dealing with estate matters, someone, assuming they've reached normal normal mortality. We may be meeting somebody who's in their 40s or 50s. Their 80-year-old parent has passed away.
Right, right.
Or it can be a younger. I mean, if it's a spouse, it could be a relationship where the person has had a heart attack or been killed in an accident, or so they may be younger. And now we're looking at the actual will. We're reading it, and we're looking at the absence of any gift for this person, or a gift that they feel is unfair, and that they want the court to vary that gift.
All right, now you've opened the door ever so wonderfully with the word gift here, David, because in terms of people, Ian, talking and placing themselves in a position whereby their will avoid challenges after their death, the whole matter of gifting is a strategy employed by a lot of people, isn't it?
Yes, I mean, the Sterling, there's essentially a will provides for gifting after death.
Okay.
But in order to a strategy that a will maker might bring to avoiding a will's variation claim, where he or she wants to perhaps treat one child or their spouse less favorably than they might otherwise do so under the will, and they're fearful that there will be a will's variation claim.
Right.
They can create gifts or divest themselves of their estate during their lifetime by creating gifts during their lifetime, which may take effect during lifetime or may take effect upon their passing.
Well, it's
outside the will.
Time-wise, it's great. It's December 1st. It's the giving season, day one, although, of course, we did make it through Black Friday a while back. But nonetheless, David, when we're talking about gifting, is this a tax strategy, or is there more attached to it than just avoiding probate fees, which are will taxes, basically, right?
Well, correct. I mean, if we dissect the idea of a gift a little bit, a gift is, the characteristic of a gift is that I received something and I gave nothing in return for it.
Right.
So hence my Christmas present under the tree, or my grandmother sends me a check in the mail and says, this is for you, you're a wonderful son or grandson, and so on, those kinds of ideas. But the essence of it is I received something, I've given nothing in return for it.
Okay.
Another kind of dissecting point is that wills gift things to people because you're being given something, you give nothing for it, but we call it a testamentary gift because it's the gift is in the will. I pass away and I now start gifting things to people.
Oh, I see. Okay.
And so that's what we call a testamentary gift. If I'm alive, then we call it an inter vivos gift or a lifetime gift. So you can think of gifting under a will. All the gifts occur after I die.
Right.
Or you can think of gifting during my lifetime. When people want to avoid probate fee, they make gifts during their lifetime so that when they die, they don't own that property anymore, and it doesn't fall under the will and become part of the estate. So they've given it away already or gifted it away already. And people get into battles about whether or not a person intended a gift, i.e. for the recipient to own that property having given nothing for it.
Right, right.
Or whether the gift was made for some other reason, such as to simply avoid probate fee.
Ian, do most people, once they're made aware of this strategy, that you can give gifts during your lifetime to avoid, among other things, taxes and certain hurt feelings, perhaps, in later years. But is this a popular strategy? Do people employ this strategy frequently, or is this kind of new?
Oh, no, it's a long-employed strategy, and, quite frankly, sometimes it's not strategic at all. There's, I would say it's very common for in families for there to be gifts made during lifetime that of significant assets,
right,
that may otherwise have fallen under a will upon the passing of the owner.
Is it important when you give a gift for the purposes of avoiding probate fees or will taxes? Is it important that when you give that gift, the person receiving the gift understands that's why they're receiving it?
Well, I would say yes, but I think moreover, anyone who might question that it was a gift as opposed to done for some other reason, it's important that they understand And because in some circumstances, you've passed away, and people are looking for what lawyers call evidence of the intention of the person who made the gift. And the most classic and sort of obvious example of it is you go to a lawyer, and the lawyer makes a document called a deed of gift, and it records the intention of the person making the gift, and they sign it and so on. And it's a nice document that is used to prove the intention. I intended a gift. These are the reasons why I intended it. They sign it. They have legal advice. They're advised independently.
Sure.
And the deed of gift is a pretty rock solid way of removing any doubt, if you will. And conversely, if there's no evidence and very little, then all sorts of suspicions can arise as to what's really intended here.
I'm thinking, for guys like you, Ian, that this must be probably one of the hardest parts of your job when you're trying to unravel these will disputes and take one side or another for your client. Your star witness, in a lot of cases, is no longer with us. And so in this matter of proving intent, was that really intended to be a gift, or another family member saying, not a chance? You don't have that star witness around to go, well, of course I intended to do it. So how do you go at that, proving intent, when the person who did the intending isn't around?
Right. So David's alluded to a deed of gift. That's the most obvious evidence for a gift. You're looking for other documentary evidence. Was there something less formal than a deed of gift in the will maker's handwriting, saying, I've given the old Cadillac to Johnny? Is there oral evidence? Are some statements attributed to the will maker to other than the gift receiver? Oh, by the way, I've given Johnny the Cadillac.
Right. There could be corroborating statements there,
right?
Okay.
Exactly. Is there evidence to the contrary, either in writing or orally? Did the will maker, let's say Mom, did Mom say to Johnny's siblings, Johnny's been asking me about the old Cadillac, but I think I'm just going to keep it in the estate, or I'm going to give Johnny the old Cadillac because it's worth quite a bit of money, but he's my executor, and I expect him to sell it and distribute the proceeds in accordance with my will. So there's all sorts of different types of evidence that we'd be trying to determine whether it exists or not.
Okay, so is it ultimately, though, and I guess what I'm driving at here, David, is on the whole matter of devising a strategy. We're talking, about, ending your affairs at some point, but during your lifetime, if your strategy is not to own much when you die, obviously then you're going to be devoting a lot of your time to breaking your assets up into giftable size pieces and getting rid of them, aren't you?
Well, correct. I mean, if you take a more significant example, let's say it's the family home. One parent's passed away. So
I was kind of partial to the old Cadillac myself, but I'm kidding, of course.
Well, Cadillacs are emotive. They're important because they're antiques and they have emotional value. I mean, homes have emotional value too, but they're worth more money.
Absolutely.
So let's say I have a home and I'm the surviving parent, and I get together with the family or some of them, and we devise a strategy where I'm going to gift the home to my eldest son, and that's so it's not in my estate or fall under my will, and there'll be no probate fee on this many hundreds of thousands of dollars or millions of dollars home.
Right.
So now I'm saving tens of thousands of dollars in probate fee under my strategy, and I tell my son and maybe some of the other members, look, you'll sell the house and you'll distribute it 5 ways or 4 ways or 6 ways or however many kids there are.
Right, but it'll be gifted to you being the oldest child.
Right. So that all sounds pretty smart.
Right.
But there's no documentation. Nobody writes anything down. I die. The day after I die, a couple of my children come to my house and rifle the house. They retrieve the wedding dress and the silverware and and my favorite painting and a couple other things, and they leave. And they upset somebody else in the family who didn't come to the house and goes to the house and discovers that this ransacking has occurred. So now the deal becomes shaky, re the house. If I'm the one that has it in my name, I was the one it was gifted to, I'm a little upset now at my siblings for this behavior.
Sure, yeah.
The deal become shaky. There's no evidence of it other than he said, she said, and so on. And now you have the makings of a very nice battle, and everyone, people have leverage, and that's how you get into these messes.
And so the big mistake there, Ian, was that the person who gifted the house to his oldest son to be sold and the profits distributed equally among all siblings, a pretty fair setup for a parent, that person did not document one word of that whole sentiment. And therefore, it's up in the air, and it could very likely come to you as grounds for a serious battle.
Sure, absolutely, Sterling. And I do want to make one thing clear. When there's a situation like that where the legal title is given to one of the children,
right,
but the idea is that ultimately the asset will be sold and distributed equally,
right,
perhaps pursuant to the terms of the will. That's not a gift at least it's not a gift of the beneficial ownership of that property to the oldest son. It's in fact a transfer of the legal title and really the imposition of a trust obligation on the person who receives the legal title to distribute the sale proceeds or the house in accordance with the deal that was struck.
Okay, interesting stuff. Now, I need to take a break, and when we come back, thank you ever so much also, Ian, for opening another door by introducing the notion of trusts into this conversation, because that's a big part of what we're going to talk about when we come back. Our guests, David Hobbs and Ian Giroday from Hobbs Giroday in downtown Vancouver, and we're going to continue with this on The Law Show on this first day of December, right after this.
This is AM 650's The Law Show. There's more of the show still ahead.